Okay, we're going to be talking about 4 cases. The first one is Mundy, second one Warburton, third one Akinola, and the fourth one Gohill. So diving straight in to the case of Mundy. Mr. Mundy had the clever idea of going on a 5-star all-inclusive holiday to Cancun, which was supplied by the defendant, in this case, TUI UK Ltd. Unfortunately, whilst he was there, the buffet that was included in his all-inclusive deal wasn't as fresh as he'd hoped, and he suffered from a very nasty bout of food poisoning. He subsequently brought a claim for damages against TUI, including general damages for personal injury and loss of enjoyment of his holiday. This was a case where 3 Part 36 offers were made. The first 2 were made by Mr. Mundy's solicitors. The first offer was a monetary offer, to settle the claim on a global basis in the sum of £20,000. The second Part 36 offer was a liability-only offer, to fix liability on a 90-10 split in favour of the claimant. Both of those offers were rejected by TUI, who then made their own counter Part 36 offer to settle, again, a monetary sum, to settle the claim for the sum of £4,000 plus costs. Now, as it happened, when it got to the county court in Swindon, it turned out that although Mr. Mundy had indeed been given food poisoning, and it was the fault of TUI, his disastrous food poisoning wasn't quite so disastrous as he had claimed. And his plea for damages in excess of £20,000 was rejected, and the district judge hearing it awarded £3,700 in general damages instead, and £105.60 in special damages. Where that led to a position was that on monetary terms, it meant that Mr. Mundy had failed to beat TUI's offer, and the potential cost consequences would kick in. However, Mr. Mundy's solicitor said, no, you haven't they appealed and said, you haven't taken into account the fact that we made a 90-10 split on liability. And we've beaten that offer because we were awarded, you were 100% to blame for this incident. The appeal was heard before Mrs. Justice Collins Rice, but what the High Court found in Mundy was that the 90-10 liability offer couldn't be fit into the terms of CPR 3617. And effectively, by trying to squeeze it in that way, it would do violence to the provision and strain the provision to a point where it wasn't within the contemplation of the rule writers. What they found in essence was the most important offer was the monetary offer. And in this case, it was always likely to be an all or nothing approach on liability. It's unlikely that poor Mr. Mundy was somehow responsible for his own food poisoning. And so a 90-10 offer on liability didn't work. The lesson to take from this case, as I've highlighted in the handout, is consider the type of litigation you are making an offer in and whether it's appropriate to make a split in terms of liability. If there is likely to be a genuine case where it's going to be split in liability, obviously it's perfectly legitimate to make an offer on those basis. But if what you're trying to do is effectively artificially shoehorn in an advantageous position for your client on liability, then in those cases, the court's likely to say you don't get the protection of Part 36, particularly if there is a genuine competing monetary offer, which is much more easier for the court to value. The second case that we're moving on to is the case of Warburton and the Chief Constable of Avon and Somerset. Mr. Warburton was an employee of Avon and Somerset Police, and he had successfully applied for another role with Hertfordshire Constabulary. Unfortunately for Mr. Warburton, during the previous course of his employment, he'd been a bit of a naughty boy, and there'd been a number of allegations of misconduct against Mr. Warburton. I've not included them in the handout, but for your entertainment, those allegations of misconduct included performing a striptease in a student bar with some not very enthusiastic observers, and making some very, very racially insensitive remarks about colleagues of South Asian heritage. What happened was Avon and Somerset disclosed these misconduct allegations to Hertfordshire Police, who then withdrew their offer of a job to Mr. Warburton. Mr. Warburton sued Avon and Somerset for defamation. What he also did in his initial draft of his particulars of claim was he made an assertion that ANS had also breached his rights under the Data Protection Act. The pleadings got rather muddled, and it was clarified in the defence and then in the reply that the Data Protection Act allegations were background only, and the claimant confirmed in his reply that there was no claim under the DPA brought, it was for defamation alone. There was then a messy process whereby the claimant sought to amend his particulars of claim, filed and served an attempt at amending the particulars of claim, but the case cracked before the claimant was ever given formal permission to rely on these new amended pleadings. Settlement discussions took place in which it was very clear in those discussions, and there's a detailed note of this in the judgment, the citation for which I've provided in the Court of Appeal. Somerset and Avon clearly continued to deny defamation, but did, during the course of those negotiations, make admissions in relation to a breach of Mr. Warburton's data rights. There was protracted settlement discussions, and they culminated in Somerset and Avon making a Part 36 offer to settle the whole of the claim for the sum of £20,000. This offer was accepted by Mr. Warburton. What Mr. Warburton then did was issue proceedings relying solely on the breach of his data protection rights. And as part of those proceedings, he sought to rely on the admissions that had been made in the negotiation process by Somerset and Avon about the breaches of his data rights. Understandably, Somerset and Avon were a bit miffed about this, having thought that they just paid out £20,000 to settle the whole of the claim, including those data protection allegations that they had expressly admitted. The matter came before His Honour Judge Bloom in the Luton County Court, and the proceedings were struck out on using their Henderson and Henderson doctrine as an abuse of process. Mr. Warburton appealed, and what the Court of Appeal made was a series of findings that are very instructive when you're making offers to settle on mixed claims. Firstly, in Mr. Warburton's favour, what the Court of Appeal found that when there was an offer to settle the whole of the claim, that offer is only to be construed as relating to the pleaded claims. And as permission had not yet been obtained to rely on those pleaded claims, the whole of the claim didn't include the data protection. So on a strictly Part 36 basis, Avon and Somerset were in trouble. What the Court of Appeal, though, went on to consider was that where there's been an argument made about abuse of process using the Henderson doctrine, it was entirely proper for the trial judge to look into the negotiations that had gone on between the parties and consider the context of the offers that had been made. What they found in this case was that the correspondence regarding offers between the parties had made clear was that Avon and Somerset were only making an offer to pay damage in relation to the data protection breach. Mr. Warburton candidly, but perhaps foolishly, accepted during the course of the second set of proceedings that he had appreciated that the offer technically only related to the defamation proceedings, but was seeking to take advantage of a litigation mistake by the police force. Taking into account the broader context of negotiation, the Court of Appeal found that this was an abuse for the purposes of the Henderson Doctrine and allowed the claim to remain struck out. What's the lesson to take from this case? Well, make sure you're aware of both the definition of the rules, but also the context of your negotiations. The police force, by failing to appreciate the proper definition of the whole of the claim, had potentially left themselves exposed to expensive further litigation. Similarly, Mr. Warburton, had he been open in the settlement discussions that when accepting the offer, he still intended to bring further proceedings for a breach of his data rights, he may well have escaped a Henderson and Henderson abuse argument and strikeout. The third case to talk about is a High Court case from 2020, which is the case of Akinola and Oyedare. The facts in this case are long and complicated and not particularly important, save that there was a fight over a will, and the claimant, Mr. Akinola, asserted that he had a 25% beneficial interest in a series of properties. Again, without going into too much detail, the important thing to take away is that the claimant's case could generously be described as optimistic and perhaps more realistically described as absolutely hopeless. The claimant's case was ultimately at trial dismissed on all the pleaded grounds of the claim. There then came at the end a predictable dispute over costs. During the course of the litigation, what you might think was a quite curious Part 36 offer was made, and you'll see the headline in relation to this case is, make sure you actually make a Part 36 offer. The defendants make the following Part 36 offer to the claimant in terms that the claimant is invited to withdraw the claim issued on the 27th of December on a drop-hand basis and also in accordance with Part 36 of the CPR. Now, those of you who are familiar with Part 36 will know that a Part 36 offer, in order to be a Part 36 offer, normally means that the paying party is also making an offer to pay the accepting party's costs. You can't make a drop hands offer and a Part 36 offer at the same time. A drop hands offer means you're not paying any costs and everybody walks away, as I'm sure you're all familiar with, but a Part 36 offer necessarily requires you to make an offer to pay the other side's costs upon acceptance. Deputy Master Henderson set out that analysis in this judgment. Drop hands means you discontinue with everybody bearing their own costs. Further, there was no technical procedure for withdrawing a claim. You either discontinue or you obtain an order dismissing or staying the claim. But there was no means by which the offer could work in practice in accordance with the terms of Part 36. As a result of this defective offer, rather than the defendant getting their costs on the indemnity basis, which they otherwise might have been entitled to, they were only ordered to pay costs on the standard basis and so missed out on a significant chunk of money. The lesson, again, as I said at the start, is make sure the offer that you're making is actually a Part 36 offer and not something else entirely. If it's not a Part 36 offer, you can't rely on the automatic consequences that come with the Part 36 offer regime. The last case is a very recent case that I want to talk about, which is a county court decision but not binding, but interesting nonetheless because of the sums involved. Go Hill and Advantage Insurance Company was again a personal injury claim where there was a claim for damages which fell within the fixed cost regime in personal injury claims. The case was compromised on damages with parties then to file written submissions on the issue of costs. What you'll see is the claimant, Mr. Go Hill's fixed costs, came to a total of £4,937.07. His solicitors made a very generous Part 36 offer in the sum of £4,937, offering the discount of 7 pence on their overall costs entitlement. The offer was rejected, and the fixed costs were subsequently assessed in the sum of £4,937.07. The claimant attempted to argue that they'd successfully beaten their own Part 36 offer and was therefore entitled to the usual benefits afforded by doing the same. The court, however, had other ideas, and what they found, what District Judge Griffith, sitting in the County Court Birmingham, found, was that the offer was not a genuine attempt to settle the dispute and was tantamount to asking the defendant, Advantage Insurance, to completely capitulate their position. I must say, my view is that that's pretty harsh on the claimant. This was a fixed costs case. The only ever outcome that there was going to be was that the costs were going to be assessed in the sum of 493707. And in my view, defendants were pretty unreasonable by refusing to accept that offer and put everybody to the cost of a hearing, despite the fact that that was the inevitable outcome. That was not the opinion of District Judge Griffith, and the lesson to take from it is that the courts will still regularly give consideration to the now 21-year-old case of Hook and Robson and consider whether or not the offer to settle being made by a party was a genuine, realistic offer to resolve a dispute by agreement. If it appears when you make your offer that it's not genuine and you are being overly harsh, or it's not a genuine attempt to compromise, then you may well end up losing, despite beating your offer, the protection and benefits afforded by Part 36.